kick us off in this discussion on merger policy in digital market, we have Rich Gilbert. Rich Gilbert is Emeritus Distinguished Professor of Economics at the University of California at Berkeley and is also a senior consultant at Compass Lexicon. Rich has also experience on the other side. He was from 1993 to 1995 Deputy Assistant Attorney General in the Antitrust Division of the DOJ, where he led the effort that developed the Department of Justice and Federal Trade Commission antitrust guidelines for the licensing of intellectual property. He also served as chair of the Berkeley Economics Department from 2002 to 2005, president of the Industrial Organization Society from 1994 to 1995, and a non-lawyer representative to the Council of the Antitrust Section of the American Bar Association from 2011 to 2014. Rich current research specialties are in the area of competition policy, intellectual property, and innovation. He is author of numerous research papers and the book Innovation Matters, Competition Policy for the High Technology Economy. Rich, the floor is yours.
Okay, thank you, Benoit, and thank you to the organizers of this conference. It's great to be here. I want to get us started by posing a list of questions that I think are relevant to the role of a dynamic capabilities framework for merger policy, particularly in digital industries. So, let's see if we can get started. So I'll start off, I'll read these questions, and then I will give, time permitting, some brief responses. One question right away is, has merger enforcement ignored innovation so far? The second question is, have enforcers systematically made errors in the digital economy because they have ignored innovation? A third question is that, have enforcers made mistakes, in particular because they have ignored the insights from a dynamic capabilities framework? And then I want to ask, can appreciation of a dynamic capabilities framework improve merger enforcement? And I want to address that question both from an economics perspective and also a legal perspective. Now, I am not a lawyer. Most of what I know about the law comes from Doug Melamed, who is here, and I'm going to count on Doug to keep me straight if I mangled the law. But I do think we need to talk about both the law as well as the economics. And one of the nice things about this conference is that we have that interdisciplinary representation here. We can talk about both. And then finally, I want to ask about some other applications that are related to merger enforcement, if not quite exactly the same thing, for which dynamic capabilities can be very appropriate as a framework. Okay, a little bit of history here, and I also want to mix in some personal history myself. So prior to around the mid-1990s, you couldn't find innovation in merger enforcement to any extent. You know, maybe you could find a little bit in a footnote somewhere, but that's about it. Then some things happened in the mid-1990s. There were a bunch of FTC cases, which I will not claim responsibility for. There were some other cases for which I was very much involved. You know, I went to the Antitrust Division in 1993, and I had been working on antitrust or thinking about innovation really since 1980, and I will also credit David here and his co-author Tom Jordy for thinking about innovation and how it relates to antitrust. And so when I went to the division, innovation was very much on my mind. And we had a great case. This case was GM ZF Friedrichshafen. And the case involved heavy-duty transmissions, automatic transmissions for trucks. Now, what was interesting about this case was that GM and ZF competed pretty much head-on in Europe. They didn't compete very much in the US. ZF was just sort of a toehold player. But we were concerned that this merger would have innovation consequences, not just in Europe, but also for people in the US, because the innovations would spill over to the US market. But we couldn't really challenge this merger very well because, you know, in the US, if you confined it to US static effects in the US, arguably there wouldn't be very many. So we challenged it, and we challenged it mostly on innovation grounds. And we even introduced the concept of an innovation market in this case. Now, it's too bad that it didn't actually get litigated. It would have been an interesting case to litigate. They did call off the merger. The other thing that I did when I was at the division was as Benoit mentioned, I led this effort to develop antitrust guidelines for the licensing of intellectual property. And we updated some very out-of-date guidelines, and they were published in '95. They were revised in 2017 with almost no changes. Those guidelines had what we called an innovation market. The only real change in the 2017 guidelines was that they renamed it a research and development market. And I think it's worth saying what they said and what we said a innovation market is, or now it's called a research and development market. So a research and development market consists of the assets comprising research and development related to the identification of a commercializable product or directed to particular new or improved goods or processes and the close substitutes for that research and development. Now, we didn't say capabilities, but I think there's an overlap there. I think that definition needs a lot of work still. It's still a work in progress. But I think it is, in many ways, related to the dynamic capabilities approach. And we should, I did ask Susan Athey about why it didn't make it into the merger guidelines. We haven't quite made it into the merger guidelines yet, but maybe one day. Okay, let me just go on here. So the next question that I was going to address is, have enforcers systematically made over-enforcement errors in the digital economy because they ignored innovation? Well, if we look up to about 2020 or so, what we might call the forbearance period or the permissive period, if we look at the number of acquisitions that were made in this period, they number at least 700, possibly more because they're hard to count. And of all these acquisitions, the agencies didn't block any of them. They only, to my knowledge, maybe I might be missing something, but to my knowledge, they only even conditioned one merger on a remedy. It was a behavioral remedy, and the merger was an acquisition by Google of a flight managing software service, and they required some licensing of that. So it's hard to look at this list and say there was over-enforcement in this period. Now, I think it's interesting to ask why. Why was there so little intervention over this period? Well, most of these mergers were not horizontal, mergers and acquisitions, although quite a few were, actually. They were at least horizontal, or at least the acquisition of complements that could have grown into competitors, or at least in niche competitors. There's good surveys of this from the folks that I listed, including Mark, who is here with us today. Another argument is that these mergers and acquisitions allowed the digital platforms to utilize merger-specific economies of scope and scale to expand efficiently into related services, and the enforcement agencies understood this, and they let them go for that reason. Now, a lot of these numbers were also what we call acqui-hires. They were just ways acquiring talent, and those types of mergers could be anti-competitive, but I don't think the agencies have a clue about how to challenge mergers of just talent at this point. So those are some possibly good reasons for these outcomes, but there are also some reasons that may be, less charitable explanations. For example, many acquisitions weren't reported. They were below what we call the Hart-Scott-Rodino reporting thresholds, and so they came under the radar. Now, that doesn't mean you can't go back and undo these mergers, but it's hard to do. So, some of them just might have escaped detection. Most of these acquisitions were of very young firms, and some of them were also what we call nascent competitors, meaning that they could grow into competitors. They're very hard to challenge, mergers like that. So that's another reason. It doesn't mean they shouldn't be challenged, but they are hard to challenge. It also might be the case that the agencies were simply perhaps unduly risk averse when they were faced with multi-sided platforms in rapidly changing industries, and they just didn't want to get in the way. Another possibility is that they may not have triggered concentration levels that the agencies normally use to decide what kind of merger should be challenged. And if that's the case, it might well be because the market definitions were too narrow, and that they should have been broader, because it is possibly the case that complements could have grown into competitors, but they wouldn't pick it up because they're focused on whether they're only horizontal competitors. Now, so what's happened since this forbearance period? There's much more active enforcement now, as you know, particularly in Europe. The UK Competition Markets Authority forced Meta to divest Giphy. They had these little glyphs, or whatever you call them, that they use these days. Younger people use them. The European Commission conditioned Dow, DuPont, and the Bayer-Monsanto mergers on really massive R&D divestitures. I mean, they're huge divestitures. U.S. Federal Trade Commission challenged Illumina's acquisition of Grail. But it's also useful to know that at least not all courts have ignored capabilities in their evaluations. A good example is the Meta Within merger, which was reviewed by the court. And Within is a manufacturer or a seller of these applications, fitness applications for virtual reality, whatever you call them, those things. And you can think of it as Peloton for virtual reality. And the FTC challenged this as an anti-competitive acquisition, basically alleging a type of killer acquisition story. And the court evaluated this and really ultimately decided based on capabilities. And the court concluded and said, look, of course, Meta has the financial resources to do whatever they want, but they have no proven capability in developing fitness applications. And they concluded that for that reason, there was no basis to believe that this would have threatened competition if it were allowed to proceed. All right. Now we get into both the economics and the law a little bit. So the question is, can a greater appreciation of dynamic capabilities improve merger enforcement? And a claim that a merger combines capability-enhancing technologies is a type of efficiencies defense to a merger. Now, it's relevant to an enforcement decision only if static and dynamic effects are negatively correlated. And by that, what I mean is that, say there are higher prices in the short run, but they may be offset by innovation benefits in the long run. Or conversely, there may be no price effects in the short run, but an adverse effect for innovation in the longer run. They have to be negatively correlated. If they're not negatively correlated, they go in this, and they're aligned, then, for example, innovation merely provides an additional justification for enforcement actions based on static concerns, or the lack of enforcement based on static concerns. So that negative correlation is crucial. Now, the problem is, and we do need a merger innovation defense, and I enjoyed Carlos's discussion before, but you broke a streak, and I was very disappointed with that. I was keeping count. Until Carlos spoke, every presentation mentioned Mario Draghi. And I thought I was going to be the only one. So you know, he talks about the need for an innovation defense and an updated merger guidelines. I won't go through the whole thing here because apparently everybody has read Mario Draghi. So he says we need an innovation defense. And I agree, we do need an innovation defense. The problem that we have is that US antitrust law is not sympathetic to merger efficiency defenses. Now, there aren't a lot of Supreme Court cases having to do with mergers. They're old, but they've never been overruled. And in some of these famous cases, like US versus Philadelphia National Bank, the Supreme Court came out and said that Congress determined to preserve our traditionally competitive economy and therefore prescribed anti-competitive mergers, the benign and the malignant alike. Fully aware we must assume that some price might have to be paid. And then later in FTC versus Procter & Gamble, possible economies cannot be used as a defense to illegality. Now, somehow, efficiencies have worked their way into merger analysis, but it is very important to distinguish an efficiency rebuttal from an efficiency defense. They're different concepts. Now, what an efficiency rebuttal says is that when you take efficiencies into account, they neutralize the anti-competitive effects. So that, for example, if costs are low, in fact, the prices will not rise because the marginal costs are low, and therefore the efficiencies will be passed on to consumers, and so we don't have to worry about the competitive effects. Now, and some courts have allowed an efficiency rebuttal with support from the merger guidelines. We've also talked about that. Although it is notable that, to my knowledge, no US court, well, a couple of things. First of all, I'm not aware that in any case an efficiency rebuttal has actually succeeded in reversing a result based on anti-competitive arguments that were brought forth in the trial, although the court did consider it. But also, to my knowledge, I'm not aware that any US court has ever even considered an efficiency defense. And by what I mean, again, by an efficiency defense, is the sort of thing that Oliver Williamson described way back in 1980 or something like that, where you have a welfare loss triangle here, that's the harm from the merger, you have a competitive benefit over here, and you weigh those two. To my knowledge, no court has ever considered that. Now, and again, I'm counting on folks like Doug and Monsieur Genie and others to keep me straight on here if I'm out of turn on the law. Now, it's important to realize that, let me just, I think I'll skip this, I don't really need this. It's important to realize that an innovation argument, like a dynamic capabilities argument, is a form of efficiency, of an efficiency defense. It's not an efficiency rebuttal, because basically what you'd be saying is that there are some harms we have to worry about. And remember, it's only relevant to an enforcement decision when it's negatively correlated with static harms. So you have a situation where somebody's going to be harmed in the short run, and now we're going to say there are benefits. Either the benefits are going to happen in the future, or they're possibly going to happen in another market, and those benefits are going to outweigh the harms. Now, so it is an efficiency defense, not an efficiency rebuttal, which courts have not wanted to do. And then the question is, if they do it, if they did allow it, how would you actually do it? You know, should you merely assume that increased incentives for innovation more than compensate for short-term harm? Or do you actually have to do a sophisticated analysis? We have to get Ariel in here to do something like that. It's a hard thing to do. Okay. Let's see. So, how do we get the capabilities approach into merger enforcement? I think that at a minimum, it's going to be very difficult because the law is so opposed to it. I think at a minimum, you're going to need a lot of evidence, very strong evidence that there are merger-specific dynamic efficiencies. The evidence has to overcome the strong assumption that's really embedded in merger enforcement that, in fact, dynamic and static harms are not negatively correlated, they are positively correlated. When there are static harms, there are also dynamic harms as well. And that evidence has to be overcome. And it has to overcome the unwillingness of courts to accept an efficiency defense. And to do this, frankly, we might need some legislation. Possibly, but that worries me. Every time you get legislation in the antitrust area, you have to be worried about, you know, what you're asking for. All right, now, so are there other good applications of the dynamic capabilities framework to antitrust? I think there are. And the area that really appeals to me and doesn't have the hurdles that we have for merger enforcement is in the area of remedies. Now, in my book, I wouldn't think of trying to pump my book. It's called Antitrust, you know, for the high-tech industry, competition policy for the high-tech industry. You can get it from MIT Press, but I wouldn't mention that. In that book, one of the things I did was look at a lot of remedies for pharmaceutical transactions in particular. Those transactions are interesting, first of all, because there are a lot of them. There were a lot of divestitures that were remedies to address allegations of harm to innovation and acquisitions of pharmaceutical projects. And the other thing is you can actually go to clinicaltrials.org and see what actually is going on in the remedy. And unfortunately, as far as I could tell, a lot of these remedies, in fact, didn't go anywhere. And one example was there was an acquisition by American Home Products, or a merger of American Home Products and American Cyanamid, and the FTC was worried that this was going to create loss of innovation for rotavirus vaccines for diarrhea, which actually can be very serious in some cases. So they spun off the rotavirus R&D project to a company, I think it was called Korea Green Cross. It got rebranded as GC Pharma. And I looked, as far as I can tell, this company didn't do anything at all on rotaviruses. There were no clinical trials that I could find. And I think there were other examples of that as well. So what it means, I think, is that we should be thinking about the dynamic capabilities framework to identify recipients of divested assets, particularly when there are innovation concerns, who can actually do the work and actually have the capability to do the work, as well as the incentives to do the work, to restore the innovation and R&D and innovation that allegedly is lost from a transaction. Okay? But I would also say that incentives also matter here, and I want to tell a story. It's kind of an interesting story. It's about the acquisition of Novozyme by a company called Genzyme. Now, these were two companies that were both involved in research and development for something called Pompe disease. Pompe disease is a very unfortunate genetic disease that is often fatal. And this case had an interesting wrinkle, which is that the CEO of Novozyme had two children with Pompe disease. So this went to the FTC. Now, at one level, this was a merger to monopoly. These were the only two companies involved in R&D for Pompe disease. And Tim Morris, who was the chair of the FTC at the time, wrote a very long decision about this case. First half of the decision said, well, you know, it's an R&D case. We don't really know much about R&D, yada, yada, yada. I think we know something about R&D, but he kind of downplayed that a little bit. The other thing he said was, look, you know, the head of Novozyme has two kids with Pompe disease. There's no question that this research is going to go on. You know, he has a vested interest in it. So what happened? The merger proceeded, they let it go, and the merged company dropped the Novozyme project. So it was a killer acquisition. Now, you know, it's an interesting question whether it was really a killer acquisition. It might have been that the Novozyme project would have failed on its own without the merger. It might have been that there was some intellectual property or talent or something that got transferred from Novozyme to Genzyme, made their project proceed more effectively, although I couldn't find any evidence of that. You know, I think we need people like competitive strategy people to dig deep to see when is a killer acquisition really a killer acquisition. But in any case, there's a book about this particular project, about the Genzyme, Novozyme, and Pompe disease, and a movie starring Harrison Ford called Exceptional Circumstances, I think it is. So, you know, if nothing else, look, folks, you can watch the movie. So, I'll end there.
Thank you, Rich. So, thank you very much for this.